Pictet, a managed Luxembourg investment fund. And again, this is relied upon as being evidence that third parties were aware of the ability of, and could purchase bonds, the bonds in question through a fund, and indeed were, we say that, provided information to Mr. Kastner that could be done. So what we have is the judge addressed what he referred to as the Pictet experiment, which was an earlier thing at paragraph 44 of the judgment. So this is tab 7 at page 101. And so this is where Mr. Kastner in July had asked whether it was possible for Pictet to source these. Yeah? And so that's where the judge addressed that. What he didn't address is a further matter that he was cross-examined on by Mr. Green, which comes in relation to a WhatsApp message that was shown to him in cross by Mr. Green, as between Mr. Kastner and Ms. Alavatica, which was from August. And so that we can see it's just the normal supplementary bundle at tab 13. So this is at page 83. Slightly hard to read, but it's a printout of a WhatsApp message. You can see the date of it is just above the first hole punch, 5th of August 2019. And what Mr. Kastner said was, spoke with Pictet again just now. The Venez bonds they're holding sitting mostly in UCITS, which is a fund. They claim they bought them at distressed levels. Trading levels are now quoted at 15 to 17 cents on the dollar. Liquidity is still a bit of an issue. Some of their hedge fund clients are taking interest in the trade. Apparently JPM started brokering bonds again. They can get me bonds on a PA basis. I'll speak to their trader this week. Seems like stuff is moving. So in terms of knowledge being out there of the ability to invest in the opportunities with an O that the judge held was publicly available and invest in a fund vehicle and doing that, we say that shows that this was going on out there, and the judge just didn't pay any regard to it. We did draw this to his attention, that he said he hadn't addressed the separate Pictet point in between the draft judgment and final, but there was no change made. Let me just show you the cross-examination of Mr. Green in relation to that. That's in tab 42 of, again, the supplementary bundle, same bundle. On the second page within that, so page... I beg your pardon, could you give me the tab again? Sorry, tab 42. Thank you. At page 200, sorry, it's not the second page, it's far further off, 238 within there. At line 12, he starts, he was being asked about this, and he says, may I just say something on the bonds, my lord? So he says, a discussion amongst ourselves, Mr. Omori claimed that people couldn't buy bonds and it took special knowledge to buy these bonds, and therefore the fund would be attractive from a bond perspective as well. What I did then, he encouraged me to do that, was to go to my asset manager. They provided me with a list of bonds. I selected one bond to test drive whether someone like a private Swiss bank would be capable to buy bonds for an investor. I spoke to a trader, it's not a problem at all. From my perspective, that was actually very assuring. I made clear that not anyone, obviously, but yes it was, but that people, investors and European investors, could buy bonds. And then it was said to him, I think Malone relies on this, but it's very different, isn't it, buying bonds personally and setting up a fund to trade in such sanctioned bonds. It is, you had no idea of that, did you, at the time? He says, well, the vehicle through which Pictet buys a bond is a Luxembourg fund vehicle. So we just say, at that level, given the opportunities themselves, with an O, capital O, were in the public domain, that was out there that they could be purchased through a bond, and it's, in terms of matter that should fall within the exclusion of information coming from a third party, Pictet to Mr. Kastner, that of itself would exclude trade via a bond in those opportunities. So at the very high level of generality of the business opportunity, excludes those from confidential information, whatever the construction of the exclusions. Right, that was sweeping up there. So that brings me on to ground 2. Now this has 2 bases, and I'll address them compendiously. The first is relied on, it's a series of specific points of documentary evidence and materials that we say, if the judge had applied, if I'm right about the test on public domain, then these plainly put it outside of it. It would fall within the exclusion. But even if I'm wrong on the meaning of public domain, the conclusion of the judge that the materials I'm showing you did not put the business opportunity in a capital B, capital O sense in the public domain is unsustainable in the sense of when one looks at the materials that were disclosed here. And when we're looking at, I rely on that in particular on the basis of if one's addressing public domain, as my learned friend calls it, and the judge considered it, if we consider that, then the level of generality of the information being disclosed is something that feeds into the question of whether or not it had fed into the public domain or come in the public domain. And there is, we say, no basis from which the judge could have held that that business opportunity remained confidential and not in the public domain in light of the disclosures I'm going to show you, both at that high level of business opportunity, but also the marketing materials that were sent out, and this feeds into my Lord Justice Miles' question this morning of seeking a schedule. Those marketing materials, as we set out in our skeleton, contain all of the fund detail, capital F, capital D. And so if they've gone into the public domain, then those fund detail documents are also out there. We're preparing a schedule. I hope to have it to hand it up at the end of my submissions. So that's the introduction. Let me deal with the matters under my ground 2.1 and 2.2 that we refer to as one of the fund detail disseminations. Just to orientate you, these are marketing documents that were sent out before the JV by IX, that's one tranche of them, and then sent out by the people within the JV after the NDA was signed. And looking at them all, we say, although the judge held that these did not put the business opportunity or the contents of these documents into the public domain, he was wrong in the light of just what's on the document. So let me show you that and seek to make that good. First, I'll show you the judge's decision on the point, so you can see the bits he took into particular account. This is paragraphs 100 and 101. So at 101, he deals with the materials sent out before the JV, so this is IX off its own bat. So at 101, he says, prior to the JV, the Canaima Capital presentation, I'll show you that document and the emails it was sent out under, had been sent to potential investors by IX and an IX contact called Mr. Ilado. The precise number of investors to whom it was sent is not clear. We'd identified at least 17, but it was likely sent to more. It appears to have been intended to be circulated internally by the recipient to colleagues who might be interested and potential investors. However, this circulation was clearly intended to be treated as a confidential opportunity to serious potential investors, and then the matters he relies on. The presentation was marked strictly private and confidential. It was not put on the website, that's IX's website, or circulated to IX's newsletter database. It remained relatively secret because it was not circulated more widely. It was not intended to be and was not available to potential competitors to IX. As long as it didn't fall into the hands of a competitor, the confidential information in the presentation retained its value to IX. So that's the approach he's taking on public domain. As long as there's some relative value, it's in there. Now I just want to show you what was actually sent out before we get on to 102. So supplementary bundle tab 2 is an email I'll send you, I think, show you three emails under which the materials were sent out. So tab 2, this was sent out by Mr. Amore, and he just sent it out. So there's no, it's just, here goes the email. So that's one class of things that were sent out. Tab 3, we see Mr. Ilado's work, though he crops up later as well. So tab 3, this is an email of the 11th of March. Good morning, Roberto. Attached is an attractive fund with development potential in the 3 to 5 years with double return captains. Not sure what that is. The product is intended for institutional investors. Dear greeting, Antonio. It's a machine translation, unfortunately. But again, there's no suggestion of any confidentiality within that. It's a marketing document being marketed and sent out. And then tab 4, this is from Mr. Amore, so IX themselves. Dear redacted, as discussed, attached to the paid evasive promissory note docs we are in touch with to buy for us and our investors. Find attached the fund vehicle we have put together in order to allow investors to participate in the acquisition of paid evasive commercial receivables, promissory notes, and Venezuela government ICSID claims. Let me know if you interested to participate in a global vehicle pooling all the assets together. So again, this is sent out, and I would say at a level of generality of the business opportunity, the email itself is pretty much saying invest in a fund for distressed debt. But attached to each of these was what was known as the Canaima Capital presentation, and that's what the judge refers to when he says it was marked private and confidential, but it otherwise contains not only the business opportunity capital B, capital O, but also essentially the fund detail. It's got all manner of stuff to do with structure and other things in it. And that document itself can be found behind tab 2.1 of the supplementary bundle. And on the front page, what's relied on as imposing confidentiality on this, if you screw your eyes up very fine and look at the bottom in the middle, can you see some white text on the run up to St. Paul's from the river? Strictly private and confidential. That's it.
Could you also go to the first line, the first sentence?
Sorry, I'm on the front page. You go to the legal disclaimer. We then have a legal disclaimer, boilerplate. This document has been provided to you solely for your information and may not be reproduced or redistributed in whole or in part to any other person. Canaima Capital Limited is not soliciting any action based on this material. Again, that's not an imposition of confidentiality. That's regulatory materials in terms of what you can and can't do in terms of advertising in this jurisdiction or others. You look, see that right at the bottom. It's a disclaimer, not an imposition of any obligation of confidentiality. And at the base you have in capital letters, this document may not be distributed into Australia, Canada, Japan. So again, it's all about regulatory matters. But again, and that tiny text at the bottom, to be fair to my learned friend, you see strictly private and confidential. Put in there. Now that was sent out under those emails that we've seen, including from Mr. Ilado saying it's suitable for institutional investors. In my submission, there is, well, on my construction of public domain, there is nothing there that brings it, there's nothing that will prevent it from falling within the exclusion. On the judge's construction, that of itself is something that, in my words, it is not a rational decision to say that that imposed, that would in any way prevented the document being circulated from entering the public domain. And indeed, in the judge forming his conclusion that it didn't put the business opportunity at that level of generality relied on by my learned friend, as opposed to any of the details within that document, on that basis, if the level of detail in a confidential idea is something that feeds into the contextual assessment of whether something has entered the public domain, as something that communicates the business opportunity as my learned friend defined it, which is to say you can, the opportunity to invest in distressed Venezuelan debt without breaching sanctions. That concept is not something that the statements on the front page of that would trouble the conscience of the person receiving it on an equitable basis, such as say, well, I can't even tell someone that I've been alerted to a fund that allows me to invest in debt, distressed Venezuelan debt, without breaching sanctions. So, and the judge didn't even consider that generality of the public domain as, the business opportunities put forward by my learned friend when assessing that. So that was before. That's the marketing materials sent out before the joint venture.
Can I just ask you a question about the way you put that submission a moment ago? You said
yes.
it wouldn't prevent the document, leaving aside the broader, high-level definition on the other case, it wouldn't prevent the document from entering the public domain. Do you say the fact that it was sent to the handful of people in relation to this document, that put it in the public domain, or just didn't stop it thereafter being disseminated?
I'd say that put it in. So, well, if there were no obligation of confidentiality imposed in any sense, and my learned friend relies on that, or any equitable, then sending marketing material to, without any covering email saying this is confidential, sending out a promotional material that identifies here is a fund that you can invest in distressed Venezuelan debt. In my submission, it is, I guess if I say it's irrational to say that that wouldn't be putting it in the public domain in the sense of, even as my learned friend puts it, it's why would there be any relative confidentiality when you're marketing to investors?
Does it matter how many people it went to? Picking up Lord Justice Miles' point from this morning, if this went to one person, would that in itself put it in the public domain? So on the relative test the judge is applying?
Well, maybe not on the relative test. It's all a little bit more loosey-goosey, touchy-feely in terms of what things were. It's context-based is how you put it. So if it went to one, then you might say, well, that might not be enough on the public domain test advanced by my learned friend and the judge. But if you think about what is troubling the conscience, which is the test being applied in terms of public domain, has it entered the public domain? Do people receiving it think that they're free to use it? What is there in this that renders it in any sense not in the public domain? If you're sending out marketing materials, that's actually, it's the nature of the communication is important in my submission, that this is a marketing material. And in particular, we'll see in later versions, when the joint venture was sending that, it's being sent out, and the suggestion is you can send it to other people. Again, that's not keeping something. That is something that in my submission is sufficient to put it within the public domain, even on the judge's test.
Even though it only goes to 1 or 2 or 10.
So the more. I mean, if I could show you it had been sent to 1,000, then my submission would be easier on the point. But I would say that even at 1, that would suffice. But as a contextual test under that applied by the judge, then I can see that sending it only to 1 might not be enough. But if you're sending it to the numbers that the judge records here, and you're sending it to other people to circulate, then that is, in my submission, enough. So that's before the joint venture. After the joint venture was formed, 2 different sets of marketing materials were sent out. One was a presentation very similar to the one we've just seen, which is a slide deck, which has more detail. And the other is what's called a fund fact sheet, which is a summary version of it, and is sent out. I just show you again how the judge addressed those. That's paragraph 102 of the judgment. So the AICF presentation, the Canaima Fund fact sheet, so those are 2 things within the detail. The schedule of detail, those are documents he's referred to, were sent to about 200 potential investors by IX, Altana and Brevent for the purposes of the joint venture. And then he says the second slide of the AICF said it was strictly confidential and the Canaima Fund fact sheet was marked private and confidential. I'll show you where those are. Certainly on the Canaima Fund fact sheet, it is far from prominent. This was intended by IX, Altana and Brevent to be a confidential opportunity to be presented to serious potential investors. The presentation was not put on the website or sent to the wider newsletter circulation. It remained relatively secret, so this is the test he's applying, because it was not circulated more widely. It was not intended to be and was not available to potential competitors to IX. Mr. Amori said there was a general understanding in the industry that such teaser marketing was confidential. This was supported by Mr. Cassin. The tenor of Mr. Cassin and Mr. Robinson's evidence that such a gentleman's agreement existed but was not reliable, not honoured, and it was therefore preferable not to disclose confidential information in such teaser marketing. They nevertheless both confirmed that they would not have wanted the teaser marketing to be shown to a competitor. My Lord, again, the suggestion that you wouldn't want to have, the fact you wouldn't want necessarily to have a competitor see your marketing does not, in my submission, inform the question of whether or not it's entered the public domain, in that what you have done is sent it out. You send it out to your customers without stopping them from talking to other people, then it is the fact that you yourself, and you prefer your competitors not to see it, that you yourself have perhaps not sent it to your competitors, doesn't mean that it's still protectable in my submission. And they said, while a risk had been taken that it would fall into the wrong hands, it was hoped that it would remain confidential. So long as these marketing materials did not fall into the hands of a competitor, the confidential information in the presentation retained its value. So, again, on my construction, sending it out without an NDA or an obligation of confidentiality is enough. On the judge's construction, I just want to show you what was sent out and what he was addressing here. So, tab supplemental tab 18 is where Mr. Bilardo, I think. So yes, it's Mr. Illardo again, sending out the fund fact sheet, which I'll show you once I've seen this email. Good morning, Piano. I hope you're well and recommend that you fight because with the will of they can do so many things. Attached is a summary of the investment dedicated to Venezuela. When you have time and desire, take a look. As you know, I'm interested in your opinion. Yes, you can use it as a communication tool with those people you think are interesting. Have a good day and goodbye. That of itself is being sent out by Mr. Illardo, not just without restriction in terms of confidentiality, it's to be forwarded and circulated by him to others. And again, in terms of where the line is drawn on public domain, even on the judge's construction, bearing in mind the high level of business opportunity, the generality of that concept, to suggest that this is being not putting that concept of a fund in that way into the public domain is, in my submission, unsustainable. Let me show you what was circulated. Tab 16 is the fact sheet. I don't know if you've got this in colour or not, but this is a two-page sheet setting out essentially the nature of the fund that was being launched, kind of thing you might get if you were contemplating investing in it. And at the base, when the judge says it's marked private and confidential, you can see that right at the base on page 88, private and confidential is mentioned there.
So can you clarify for us, the point arises both on the previous document and this one, what was your submission about these markings? You say we just ignore that.
Well, my submission is they're not sufficient in their size, their prominence. If you were acting for for the person who had received this fund sheet, who then distributed it further on, and you were seeking to establish that they had received it subject to an equitable duty of confidence, in my submission it would be fanciful to say so, based on that level and the fact that they were sent these under emails with no no imposition of confidentiality in the email, and indeed they were invited to circulate them to others. So on that test, approaching it in that way.
So this is a kind of Thornton and Shoe Lane parking point translated into the context of confidential information. Is there any learning on that?
My lord, no. Apart from the fact that if something is going to engage with the conscience of the recipient, such that, because that's the notional test.
Yeah, well, that's
Then
about
how
the
would-
fifth time you referred to the conscience of the recipient, and I have to say I have some problems with that way of formulating it, given the current state of the law, which I have been at pains in a number of judgments to free from that concept, but that's by the by. But to return to where we were, I find it a bit odd that you say that there's no learning on that subject. I mean, I confess I'm not suggesting there's a case that springs to my mind that provides an answer, but it would seem odd, because the question is one of notice, to formulate it in more neutral terms.
My lord, yes.
And one might have thought that some of the learning on what is sufficient notice might assist, but perhaps not.
Well, my lord, I'll consider it, and if something comes in, I will draw it to the court's attention if I have the opportunity, but there's none that I refer to in my skeleton, nothing I can send from that.
Okay.
So the next point, so those are...
Sorry, just so as to be clear, because the respondent's submission is crystal clear. They say it's notice, that's enough. It doesn't matter that it's in small print. And as I say, what puzzles me at the moment is that both sides seem to be treating the matter as if it's free from authority. I mean, I may be wrong about Mr. Green's submissions, and perhaps he's got some authorities that I've overlooked, but at the moment nothing is springing to my mind. And as I say, I find that a puzzling proposition, that to treat this as if there's nothing to be learnt from previous authority, but perhaps there is nothing.
My lord,
Perhaps it's a novel point.
My lord, we rely on we also rely on the lack of prominence, not merely in the sense of notice and imposing that, but also in terms of the steps that are taken by the person disclosing, so IX and others, as not being something that would indicate to any recipient as that the business opportunity is something that is to be treated by them as confidential. There was no NDA was imposed, and this is really the least impactful way of suggesting that something might be not free to us, that one could imagine. And so we say, in terms of the steps that were taken by IX and the parties disclosing this, which include my clients, to stop these matters, to make sure that the matters sent out did not enter the public domain, there's nothing in there in terms of imposing an equitable obligation of confidentiality, which is the flip side of the public domain point. We say they really made no proper attempt to impose such an obligation.
Okay, thank you.
Next point is under, it's what I raise in the ground 2, Little Roman 3. This is the Bloomberg email.
Sorry, you've just shown us the fact sheet.
Let me show you the.
The email you showed us was actually for the presentation. Is that right?
I think it was for the fact sheet rather than the presentation.
I'm sorry, you might be right. So
But there were others sent. I haven't.
But you've mentioned the presentation as well.
Yes, the presentation is behind tab 6. 5.1. No, sorry, that's a Duff reference. Excuse me. It's at 22. Tab 22. But this to be fair, so this presentation, even to one side, Lord Justice Arnold's points on
Well, this one's
notice.
better from your point of view because it doesn't have the small writing at the bottom at all.
Well, my lord, it doesn't have the small writing, but to be fair to my learned friend, if you look at the disclaimer at the base of the next page, it does say this marketing presentation and the information contained herein is strictly confidential and intended use of the only post. So that is worse from my perspective than the you see in the final paragraph.
Yeah, okay, I've got that, thank you.
So, the Bloomberg email, an article, this is addressed for your note in my paragraph 59 of my skeleton. This is at sub tab 11. This is the email that Mr. Amore received and forwarded to the other members of the joint venture. And you see what he was sent from Bloomberg, which can in no sense be confidential or not in the public domain, but also is coming in from third parties. Competition warming up, he says. Besides, some of those names look like Russian entities scooping up paper. Exactly what Hans was worried about is happening. The subject is hedge funds buy up Venezuela's sanctioned debt after record. And then the document, the email itself from Ben Bartenstein, London hedge funds, a private bank in Monaco and Uruguayan millionaires are among the bargain hunters bidding on Venezuelan bonds. Some investors dump the debt to mirror reduced index weight. And if we look over leaf on page 80 at the top of the page, there's a quote from someone, Russ Dallin, managing partner at the Miami-based brokerage Caracas Capital. I've been getting calls from around the world looking to buy Venezuela and PDVSA bonds at these prices. So in terms of the business opportunity, setting up a fund to trade in distressed Venezuelan debt, this is, it shows that there were others out there doing it, and indeed in the secondary, the second full paragraph on page 80, says regulatory filings offer additional clues that US investors have unloaded some Venezuelan debt. Funds managed by Goldman Sachs, Vanguard Group, Lazard Limited and Frank Russell Co. were among those to trim their holdings in recent months, according to data compiled by Bloomberg. Meanwhile, buyers include Copenhagen-based Bank Invest Group, Raiffeisen Capital Enlarge GmbH, Vienna, and Meridian Group, Andorra-registered Russian combined fund. So, the business opportunity, as defined in the light of that, was simply was plainly in the public domain. There were bonds, there were funds out there trading and purchasing distressed Venezuelan debt. So the level of business opportunity at that level of generality relied on in closing, we say, is disclosed. The next ground, which is 2 at Roman 4, this is a point I've made several times already, that the only actual opportunities disclosed by IX, my clients, were in the public domain as the judge held. And we say that of itself renders the judge's findings as business opportunity not being in the public domain unsustainable. And I've shown you that. That comes from paragraph 95 of the judgment, where the judge, as I took you to earlier this morning, addresses the fact that Venezuelan debt could be traded, notwithstanding the US sanctions, was known among some specialist investors but not widely known, and then says the business opportunity, as defined, was not widely known. But in light of the judge's own finding that all of the opportunities were in the public domain, that decision, that aspect of his decision in paragraph 95, is unsustainable. It's internally inconsistent.
Where does the judge deal with the Bloomberg article?
The judge deals with the Bloomberg article in... Well, he didn't address it. What are we saying? My Lord, it was... He doesn't address it in terms of the judgment. A further point is, if one goes on to paragraph 96 in the judgment, the judge records of the submission, the defendant suggests the article published in March 2019 by David Schneider, Venezuela, an investment opportunity of a lifetime, disclosed the business opportunity, and the judge says it does not do so. While identifying the potential for a substantial turnaround in Venezuela's economic position if Nicolas Maduro left power, the focus of the article is on the long-term potential of Venezuela's future stock market, if that were to happen. It mentions the opportunity for an expert investor to invest in sovereign bonds on the cheap in passing, while declaring that it was at that time sheer impossible to invest in any Venezuelan assets, including bonds. And then he says, far from identifying the business opportunity, it reinforces the fact that even amongst commentators, the opportunity to trade in Venezuelan sovereign debt was not widely known. But, my lords, that's from March 2019. That finding, which depends in particular on the sheer impossible comment, that investment in Venezuela was not generally known, is again inconsistent. If one reads that, bearing in mind the judge's finding that investment in the bonds identified, the particular bonds that were brought by IX to the fund, was in the public domain, the knowledge that you could invest in those and not breach sanctions, then if that's in the public domain, then the paragraph, the article at 96, and indeed the Clifford Chance article, Venezuela Navigating the Storm, similarly put the business opportunity into the public domain. And the judge has apparently forgotten, as he's looking at 96 and 97, and saying it was not known that you could invest in Venezuelan assets, including bonds, that he had himself held that it was known that you could. So let me just show you what's said. So the articles themselves, Venezuela on fire. This is at a further supplementary bundle, which I hope your lordships all have now. Tab 1 is Venezuela on fire, headed Venezuela Investment Opportunity of a Lifetime. And then the passage referred to by the judge my bundles have been revised, and I now can't find that. It's at the base of, so page 8 to page 9, you have conclusion, the heading conclusion, Venezuela investment, opportunity of a lifetime, question mark. Investment strategy, as you've seen from a complicated debt situation, only bond and distressed investment experts should play this particular game. An expert investor could buy some of the sovereign bonds on the cheap to the dollar and sell at favourable outcomes depending on creditors' negotiations. All the industry pros have already put themselves into position, Elliott Management and Co. However, we see much more exciting long-term potential in Venezuela's future stock market. Certainly, so overleaf on page 9, in bold at the bottom, 22 of the bundle, certainly at this point of time, it's sheer impossible to invest in any assets involving Venezuela, including bonds. This particularly counts for US investors who are barred to invest in Venezuela. But that article and that comment, read in light of the public domain knowledge that these bonds were investable in without breaching sanctions, puts essentially the entirety of the business opportunity at the level of generality contended for by my learned friend into the public domain. And similarly, Clifford Chance which is at tab 22 of the core bundle. It's annexed to the defense. Again, this is Venezuela navigating the storm, behind tab 22, page 421. Provides, from January 2018, provides all manner of information about the nature of bonds, but the judge held that it did not disclose, he's right, it doesn't disclose that you could trade in such bonds without infringing sanctions. But again, in light of the judge's own finding that the opportunities with a capital O that were disclosed to the joint venture were all in the public domain, it is impossible, rationally in my submission, to say that this article, bearing in mind that public domain position, did not put the business opportunity at its highest level, as relied on by my learned friend, at high level, into the public domain. And against that, my learned friend, this is where my learned friend says that the awareness that these bonds could be traded in is different from the business opportunity, and he seeks to bring in other aspects of the detail into his business opportunity, notwithstanding having abandoned them at trial. And then, before we leave this area of the judgment, paragraph 95, again, remind you that the judge himself held that Copernico, this other fund, was trading. One other fund which was established, so this is a fund that was established to trade in a sanction-compliant way, and IX's own evidence, which you can see at tab 63, tab 31, paragraph 63, Mr. Amori's evidence, was that this fund was up and running by 2019. So the judge, this is in the supplementary bundle.
Oh, there is a tab.
Sorry, it's tab 31, paragraph 63 in tab 31. Thank you for your assistance. At the base of paragraph 63 on page 179, he says, he's talking to, says, I did hear about one other bond investor who had apparently travelled to Caracas, Jorge Piedrahita. He was a fund manager who I knew from many years before. When I met him, he was working in Global Emerging Markets Fund Macro Synergy, which I knew had invested heavily in Venezuelan debt pre-default, but by 2019 he'd moved to Uruguay to manage Copernico Capital Partners, a Uruguayan asset manager, where he continued to manage a Venezuelan debt-dedicated fund called the Copernico Recovery Fund. So just to be clear, the judge is himself holding that there was another fund out there that was trading in these matters. And to suggest that the business opportunity, in the light of that, was not in the public domain is, in my submission, not sustainable on the evidence before. So, and then so I'm acutely aware of the time passing. Ground 2.5 of my appeal paragraph 63 of my skeleton, if you'll note, there's a reference to a telephone call transcript from 10th of May 2019, which is a supplementary bundle tab 6. This is not mentioned at all by the judge. They referred to him in submissions. And this is from, it's IX recorded their calls when they were discussing matters with my client. So when first talking about the business opportunity, on page, so behind this tab, it's a transcript, starts at page 63, on 64, under B to D, you have Mr. Amore talking about this idea and where he got it from. He says, no, actually, we met some hedge funds last week in New York, and they told me, I know that you can source for us, you have this thing, but we cannot buy, so why don't you set up your own vehicle? It's crazy that Europeans are not setting up these things. We have a lot of Europeans. I don't see any European buying at the moment. Asia and Russia. I don't know a lot of investors there. So basically, we've decided our own vehicle. Because these days, not a lot of people are following the situation or they're interested to get in now. So we decided to put, some family office people that we know, professional investors, and say, look, this is the opportunity. Why do you not look at this? So this is something that was referred to IX from other funds, albeit that they were American funds and couldn't do it. And again, looked at this in light of the judge's finding again that the opportunities with the capital O were not, were in the public domain. It is extraordinary that he held that the business opportunity at that high level of generality was not itself in the public domain. And then finally, ground 2, Roman 5, 6. This is Professor Olivares Caminal's legal advice. Now, so, my lords, my submission here is that the content of Professor Olivares Caminal's legal advice, this is somewhat of a subsidiary point, in that if I'm successful on the business opportunity not being protected, the judge, and will provide you with the schedule I'll just hand up, which says where we say all those points of detail are disclosed in the materials we're talking about. The judge nonetheless held that aspects of the advice of Professor Olivares Caminal was misused. That's item W of the detail. And I just want to show you the advice in question, which is Supplementary Bundle, tab 21.1. So this is, 21 of itself is the email from Olivares Caminal, and then a note on statute of limitations. Statute of limitations is behind the next tab, 21.1. And this is the material that the judge held was confidential, in precisely this form, and then held was misused. But it does nothing more than set out a statute of limitations as the defence described that, describe the rule for accrual of limitation, and draw a distinction between the statute of limitation for interest payments and the principal. So these matters. And then says that Altana Illiquidx Ltd will assist you not only in providing unique access to the return opportunities, but also managing the debt instruments. So it's at a very high level of generality, referring to those matters, but the judge says nothing more than identifying the effect of limitations and prescriptions clauses with regard to the known bonds. But the judge himself held that those prescription clauses had been put into were themselves, knowledge of those was in the public domain. And you see that from detail I in the schedule. So let's, at tab 7, page 128. We have here what's referred to as the September email, and you'll see this is not read. Mr. Amore sent an email about financial prescriptions to Mr. Robinson, Ms. Alabachka and Mr. Caston. And so it's saying, in this email, he thought the situation might be critical with half Venezuelan bonds interest prescribing before July 2020, as soon as April 13th in the case of the Venezuela 7%. Now, that itself, if we look at the permitted disclosure column, it's not inherently confidential information, as prescription deadlines could be calculated from the publicly available call terms of the bonds. The information in the email was published by IX in its newsletter on the same day it was sent to the defendants. So insofar as Olivares Caminal is just repeating in his advice, and that's all he's doing, this material, it itself, we say, is in the public domain. And so, in my submission, unless, so if you were with me on the business opportunity not being protected, then this aspect of the detail, Professor Olivares Caminal's one-page advice, is not itself misused in light of the judge's other findings of what was in the public domain, including the one I've just shown you in relation to prescription periods. And similarly, I think there's another advice in a trustee and fiscal agency memo. Again, all of the information contained in that is within the Clifford Chance article that we have looked at. So, my Lord, sorry, that is, I'm 3 minutes over.
You wouldn't worry, we did start slightly late, so...
I know, well, that's a match to go through. But I was asked
a few more minutes this afternoon to make up the time.
I'm obliged. May I pass up? There is a but I was asked to provide a schedule saying which items of the detail we challenge, if I'm there's detail I challenge as part of the overarching point of business opportunity, but there are also individual points of detail that we say, where we say those were put into the public domain, and what points I've made in my skeleton where that comes out on that point. If I can, I think my Lord Justice Miles asked me the question. If I can hand up this schedule, which just refers to the relevant ground of appeal and the part of our skeleton that deals with it, that covers the point. My Lords, unless I can assist you further, those are my submissions.
Well, let's have a quick look at the schedule. Thank you. All right, thank you. Yes, Mr. Green.
My Lord, can I deal first of all with ground one, the construction of public domain? And Illiquidx's position can be summarised in 4 short points. The first point is that the parties expressly chose to use a phrase with a well-established legal meaning in the law of confidence, and thereby demonstrated an objective intention that that well-established meaning should apply. The second point is that there is nothing in the wording of the NDA, nor is there any factual matrix evidence which demonstrates an objective intention to depart from the established legal meaning of the words public domain. The third point is that there is nothing impractical or uncommercial about Illiquidx's construction of the words public domain. And the fourth and final point is there is nothing in the wording of the NDA or by way of factual matrix evidence to support the appellant's bespoke construction. And if the parties had intended that construction, which bears some resemblance to the patent law test, they would have used words which explicitly conveyed that intent, but they didn't. Now, before addressing my lords on each of those 4 points, which I will do relatively briefly, can I just identify what my learned friend's construction is? Because I think it's been a bit of a movable feast. Could you just take the grounds of appeal at paragraph 1.1, which you find in the core bundle, tab 1, at page 15, and going over to page 16, it's in the first subparagraph up at the top, and he says in line 3, the judge, having set out the spy catcher test, he then says the judge should have accepted the submission of the defendants' appellants that on its correct construction, the term public domain excluded from protection any material that was available or had been disclosed without being subject to a duty of confidentiality. And that is also reflected in paragraph 45 of my learned friend's skeleton argument. So it's not just about disclosure, as he tried to suggest today, but it's also about availability. So what that would mean, for example, potentially, is something would be in the public domain if one clever analyst, or perhaps 2 clever analysts in Siberia, had come up with the same business opportunity, but never disclosed it to anybody, perhaps kept it within their computers or within their brains.
How is that available?
Well, it is on my learned friend's test. It is available in the sense that they have access to it. They can send it out to anybody. They are free to use it in law and equity, and therefore, arguably, it appears to be available. But I don't wish to push the point. But certainly, my learned friend has cut down his analysis or his construction to say it's all about disclosure. But certainly, his position, as per the grounds of appeal and as per paragraph 45 of his skeleton, is that it is also about availability in addition to disclosure. But can I then deal with the first of my 4 points, which is that the parties expressly chose to use a phrase with a well-established meaning and thereby demonstrated an objective intention to adopt it. Now, can we just look at 2 Court of Appeal authorities for the purpose of seeing how courts approach the construction of contracts which contain phrases with established legal meanings, meanings which might also be called terms of art or technical meanings. And can we start with the authorities bundle, tab 15, and this is the case of Marlborough Knightsbridge Management and Fivaz, where the Court of Appeal was dealing with the meaning of the phrase landlord's fixtures in a domestic lease. And my Lord Justice Arnold will obviously have some familiarity with this case, as you were one of the members of the court and gave the lead judgment. And we see at C, the tenant was the registered proprietor of the long leasehold interest in 2 flats in a block owned by the landlord. The leases contained various covenants, including a covenant not to remove any of the landlord's fixtures without consent. The tenant removed and replaced the entrance doors to both flats without seeking or receiving the consent. The landlord applied under section 168 for a determination that a breach of the covenant or condition in the leases had occurred. The first tier tribunal allowed the application, but the upper tribunal allowed the tenant's appeal on the grounds that the doors were not landlord's fixtures, but were part of the land demise to the tenant. The landlord appealed, dismissing the appeal that the term landlord's fixtures in a lease connoted things which the landlord had affixed to the premises after the structure of the demise premises had been completed, that therefore a landlord's fixture could not include a thing which formed part of the original structure of the demise premises, and so on. Now, I just want to take the court to paragraphs 11 and 12, please, in my Lord Justice Arnold's judgment. And there, under the heading, were the doors landlord's fixtures, 11, it's common ground that in order to determine whether the doors were landlord's fixtures within the meaning of clause 3.4 of the lease, it's necessary to construe the lease as applying ordinary principles of contractual interpretation. It is also common ground, however, that the expression landlord's fixtures, with or without the apostrophe, is one which has a very long usage in this area of the law, which is plainly why it was adopted by the person who drafted the leases. It is therefore idle to suppose that it was intended that it should be interpreted as if it were free from any technical meaning. Both sides' primary contention is that the established meaning of the expression supports their case, but in the alternative they rely on the specific terms. And then paragraph 12, a number of eminent judges have criticised the term. In Elliott and Bishop, it was described as a most inaccurate one. Then elsewhere it was described as not a happy expression. Lord Justice Scrutton said that he'd always had a difficulty in understanding what is meant by landlord's fixtures. It is generally accepted, however, and not in dispute in the present case, that landlord's fixtures are fixtures which are not tenants' fixtures. It's not suggested by the tenant that if the doors were fixtures, they were tenants' fixtures. Thus the real issue is whether they were fixtures at all. So we've got a clear statement that when construing a phrase in a contract in respect of which there are established legal principles, so what my Lord Justice Arnold there refers to as a technical meaning, the parties are taken to have objectively intended the application of that meaning of those principles. And of course, that doesn't mean that there's a single sentence which can encapsulate the meaning of the phrase, as indeed we see in paragraph 12. It's apparent there's no single settled meaning of the phrase landlord's fixtures. On the contrary, there's a debate about what exactly it entails. So there's some fuzziness around the edges, but there are certain established principles, there's the technical meaning, and by using the phrase landlord's fixtures, the parties are taken as having agreed to the application of that meaning, those legal principles. My Lords, can I then take you briefly to the infinite land case, which my learned friend took you to briefly, and that's at tab 5. And you will recall that the issue there, or one of the issues, was the meaning of the phrase actual knowledge in the SPA. And my learned friend took you to page 62, where first of all we have paragraphs F to G, a summary. But he then took you to paragraph 82 in the judgment of Lord Justice Chadwick, which he said assists him, we say assists us. But can I also take you to paragraphs 87 and 88 in the judgment of Lord Justice Carnworth? And what he says in 87 is, I also agree with Lord Justice Chadwick's view of 7.4 in simple terms, as I understand conventional legal usage. Actual knowledge connotes a person's own knowledge, as distinct from knowledge which the law attributes to him either because he ought to have it, constructive knowledge, or because it's knowledge of his agent, imputed knowledge. The distinctions are well established, even if the precise boundaries and demarcation lines may sometimes become blurred, particularly in the difficult area of corporate knowledge. In my view, it is important in the interests of legal certainty that such established distinctions should be respected both by those drafting contracts and by the courts in their interpretation. In the context of a professionally drawn legal document such as this, the court should start from a strong presumption that such expressions are used in their ordinary legal meanings. With respect to Lord Justice Pill, who takes a different view, I don't think the present context provides sufficient reason to displace the primary meaning of the expression actual knowledge. So again, a clear Court of Appeal statement that where a phrase has an ordinary legal meaning or a conventional legal usage, there is a strong presumption, certainly in a professionally drafted legal document, that the parties objectively intended to adopt that meaning, even though precise boundaries and demarcation lines may become blurred. Now, my Lords, insofar as it matters, although the NDA in the present case wasn't drafted from scratch by lawyers, it was drafted using a professionally drafted legal template or precedent, as the judge found in paragraph 68 of his judgment, and it was reviewed and amended by Illiquidx's lawyers, and this was communicated to the appellants. And just for your notes, we've identified the relevant passages in our skeleton at paragraph 25. Can I take you to one paragraph in the speech of Lord Simon in the Privy Council in the case of Faulkner and Commissioner of Stamp Duties. That's in tab 3 of your bundle, and we quote it, or we refer to it in paragraph 24b of our skeleton. And the relevant passage is on page 44 at F. Certain words have been legally construed. There they were dealing with the phrase next of kin. Certain words have been legally construed as having a prima facie meaning not generally differing from their most ordinary meaning when contained in documents intended to have legal effect, particularly wills and settlements. In the absence of a contrary intention appearing, the court will assume that it's this prima facie meaning which was intended. Such a rule has manifest advantages. In the first place, the existence of the rule will enable legal advisers to predict how a court will construe the words in various circumstances within the contemplation of client and advisers, and if the prima facie legal meaning does not represent the client's intention, to make that intention plain. Secondly, the rule leads to economy. The meaning need not be spelled out at length, but words can rather be used in the knowledge they will prima facie carry the meaning they put on them. Thirdly, if, as often happens, the actual forensic situation was probably not foreseen, the court is relieved from a purely impressionistic interpretation which might well vary from judge to judge, and the unsuccessful litigant will at least have the consolation of knowing that his case has been judged by an objective standard, and so on. Now, the principle that absent contrary indication, parties are presumed to intend to adopt a well-established legal meaning when they use those words, it is also supported by the legal principle that we have stated in our skeleton at paragraph 24a, little 1, which is that parties must be taken to know the general law. There are two cases in the authorities bundle which in one sense are slightly closer to the present case, and they're the cases of Salt Ship Design and Prismium in the Commercial Court and Force India in the Court of Appeal. Now, in each of those cases, the relevant contract contained a confidentiality provision with a carve-out for documents in the public domain. And the court, when dealing with claims for misuse, contractual misuse of confidential information, had to consider a defence that the information had in fact got into the public domain. Now, in neither case was there any suggestion that the phrase public domain bore some special meaning. Now, I can't and I don't place too much reliance on those cases because there wasn't any suggestion that the phrase public domain should bear a bespoke meaning, and so the court wasn't deciding how to construe the phrase in a contractual context. But it is notable that it was simply taken as read in the contractual context of those particular cases, that the public domain defences would be considered in light of the established legal meaning rather than through the prism of a bespoke meaning. So, in conclusion on my first point, the position is that the parties in a contract which was specifically dealing with the protection of confidential information expressly chose to use a phrase with a well-established legal meaning in the law of confidence, and they thereby clearly demonstrated an objective intention to adopt that established meaning. And indeed, if you ask the question, what wording would the parties have had to use in order to express an objective intention to adopt this well-established legal meaning, the answer is the very words they did use. What more could and should they have done? And the answer is nothing. They did that which was expected of them. So that's my first point. My second point is that there is nothing in the wording of the NDA, nor is there any factual matrix evidence which demonstrates an objective intention to depart from the established legal meaning of the phrase public domain. So can I deal with contractual wording and then I'll come on to factual matrix? And can I ask your lordships to look at the appellant skeleton here to see what, if anything, they rely on? Now, in paragraph 42.1, here they give a reason rooted in the text of the NDA as to why the parties must have intended to depart from the established meaning of public domain. And their argument, and my learned friend developed it today, is that because the parties agreed such a broad definition of confidential information, they must have intended a public domain carve-out which cut down the breadth of what would otherwise have been protected. And that was rightly rejected by the judge as an argument without any force. And if you just go to his judgment at paragraph 93, where he deals with it, and he says, if about six lines down, if the definition of confidential information is wide, that indicates, as a matter of objective construction, that the NDA was intended to protect more information rather than less. And we say that logic is impeccable. And indeed, if the parties had intended the words public domain to perform some sort of restrictive rebalancing exercise because of the breadth of confidential information, they would obviously have made that clear by identifying the bespoke meaning that they intended. But they didn't, because they didn't intend any such rebalancing exercise. So that argument in 42.1 is plainly, we say, hopeless. If you then look at 42.2, about 10 lines from the end, my learned friend makes the point that it is unreal to think that the parties would ever have had in mind the abstruse principles of law in the law of confidence. Now, if this is a reference to their subjective intentions, it's irrelevant. And if it's a reference to their objective intention or to the objective intentions of reasonable parties, it's simply wrong, because as the cases we've just seen make clear, that's precisely what reasonable parties would have had in mind. But it's also wrong in the light of clause 1.1d of the NDA itself. If I can just invite my lords to turn that up briefly, because 1.1d expresses in tab 11 of the core bundle, expressly refers to any obligation of confidence in the second line. So plainly, the parties did have in mind those principles. Now, one other point that we have made about clause 1.1d is that it's entirely compatible with Illiquidx's construction of public domain, but it's in real tension with my learned friend's construction. Because on his construction, the fact that information is in the possession or control of a third party, if it's available to that third party, and that third party is free to use it, then it's in the public domain. And if that's the case, it's difficult to see that there is any independent life in clause 1.1d. 1.1a and b will cover everything, will cover every situation that 1.1d would otherwise cover. So those are the contractual provisions that my learned friend relies on. I'm going to deal with clause 3b in the context of his impracticality arguments, which is my third point, because that's where they feature in his skeleton. And so I'm not going to ignore that. I just wanted to deal very briefly with factual matrix evidence, whether there's any factual matrix evidence which indicates an intention to depart from the usual meaning of public domain. We were looking a moment ago in paragraph 42.2 of my learned friend's skeleton argument. Just if we can just go back to that, in a few lines above the sentences that I took you to a moment ago, my learned friend, having criticised the judge, he then says, had he applied the correct principles of construction and attempted to discern the objective or ordinary meaning, he ought to have held that the meaning was not to be found in legal authorities, but by considering the context of the NDA as a whole and the implications and consequences of the construction for the operation and purposes of the NDA. And what you will note is that no context is then identified, and indeed none is identified in the grounds of appeal. So there is no relevant factual matrix evidence on which my learned friend can and does rely. So that deals with the second of my 4 points. The third is that there's nothing impractical or uncommercial about Illiquidx's construction. And if we can just consider each of my learned friend's impracticality arguments that he raises in his skeleton and that he developed today, at 42.3, if you just go to page 15 at the top, he says, on the judge's construction, it would be practically impossible for the parties ever to know or determine whether a particular piece of information was sufficiently generally accessible so as to be carved out, except perhaps in the most clear-cut cases. Now, if this were a valid criticism, and this picks up on an exchange my Lord Justice Arnold was having with my learned friend, it would apply in almost every case where the phrase public domain bears its well-established legal meaning. So it is in effect an attack on the case law in this area, and it implies that the established test is somehow unworkable. Now, we say that is simply hopeless. We do, of course, accept that it's always a context and fact-sensitive evaluation as to whether or not information has come into the public domain. And sometimes, yes, the answer will be obvious, and at other times it won't be. And if the parties disagree, they can litigate and a judge will decide. But that doesn't make it impractical or impossible. And indeed, the appellant's construction, insofar as one is certain what it is more likely to be impractical in its application, precisely because it will almost certainly involve inquiry into matters which aren't generally known, which aren't generally accessible. So, in fact, it's more likely to be a problematic construction in terms of its application. We then go to paragraph 43 of their skeleton, and this is the 3B point. And so the assertion is that the impracticality of the judge's construction can be tested by considering its effect on the freedom to compete clause at 3B of the NDA. Now, there is absolutely nothing in 3B that gives any clue one way or the other as to the meaning of the phrase public domain. What 3B does make clear by use of the proviso, starting with the words except that, is that the freedom to compete is subject to the proviso that the appellants can't compete against Illiquidx using any of Illiquidx's confidential information. So if, for example, Illiquidx's confidential information isn't in the public domain, the appellants can't compete using that information. But that tells you nothing about when the information enters the public domain. Now, one notable feature of 3B is that the prohibition is that Altana and Brevent can't compete using any of Illiquidx's confidential information, but there's no corresponding prohibition on Illiquidx competing using any of Altana and Brevent's confidential information. And the question is, why not? And the answer is that what this reflects is that what was understood by the parties was that Illiquidx, and only Illiquidx, would be providing information which could be used by the other parties for competitive purposes. Altana and Brevent simply weren't going to be providing information to Illiquidx which would enable it to compete with Altana and Brevent. And can I just take you to our skeleton argument at paragraph 32, where we set out what is relevant matrix evidence in this regard. And my learned friend also took you to various of these provisions in the joint venture agreement, And the point that we're making here, and is obviously correct, is that under the joint venture agreement, the overall deal was that Illiquidx would provide the information, the appellants would seek to raise money, and if it didn't work out, Illiquidx could walk away. And so that's what the parties were anticipating. And can I ask you at this point to dip in to the judgment at paragraph 106, where, tab 7, page 117, where the judge says this: I'm satisfied that prior to their contact with Illiquidx, neither Mr. Robinson nor Mr. Kastner were aware of the ability to create a sanction-compliant fund to trade in distressed Venezuelan debt. This reinforces the point this was not in the public domain if someone of Mr. Robinson's expertise was not aware of it. It also confirms that they took the idea from Illiquidx, as there are no other alternative sources for that idea. I should just say there is no appeal against any of the factual findings in paragraph 106. But what clause 3b was making clear was that if the joint venture wasn't pursued, the parties could compete, but the appellants couldn't compete using Illiquidx's confidential information, which included the idea, as referred to by the judge in paragraph 106. And one has to ask, what on earth is uncommercial about that? The answer is nothing. They could compete if, for example, Altana and Brevent could compete if, for example, they'd come up with the idea independently, or if it was in the public domain. But otherwise, they couldn't compete using Illiquidx's confidential information. And that is entirely fair and understandable and commercial. And on the contrary, it's the appellant's position that is utterly uncommercial. Their position is that Illiquidx introduced them to, or the position, rather, is that Illiquidx introduced them to a highly commercial opportunity about which they knew absolutely nothing. The introduction was for the purpose of a joint exploitation by Illiquidx and the appellants. Once the NDA was in place, Illiquidx then educate the appellants as to how they could jointly exploit the opportunity, but the joint exploitation didn't work out. Now, on the appellant's view of the NDA, it was then entirely permissible for them to exploit the opportunity on their own and in competition with, and so to the detriment of Illiquidx. Now that is utterly uncommercial and precisely what the NDA, including 3b, was designed to prevent. And that's what Mr. Amore referred to as ludicrous. This would be handing them the keys to the castle. Now, just going back to paragraph 43 of my learned friend's skeleton argument, where he's still dealing with clause 3b. And this is where he brings in the 38 bonds. Now, the key point is that the fact that 38 bonds were tradable and that this was in the public domain is completely irrelevant to the issue of construction of the phrase public domain. It tells you nothing about whose construction is correct. But in any event, there was nothing impractical about preventing Altana and Brevent from setting up and marketing to investors a fund which could trade these 38 bonds. If Lee Robinson and Mr. Kastner wanted to buy bonds in a wanted to buy these 38 bonds in a personal capacity, they could do so, although they never did. But what they couldn't do was they couldn't set up and market a fund for that purpose if by doing so they were using Illiquidx's confidential information. That's what 3b says you can't do. Now, where the point about the tradability of the 38 bonds is in theory relevant is in relation to ground 2, because there, and I'm going to deal with it in a little bit more detail there, because the issue there is this: if it was in the public domain that these 38 bonds could be traded, and was it therefore also in the public domain that one could set up a fund to trade them? That's the argument that my learned friend was trying to articulate, or did articulate. And I should just say, that point was never raised in front of the trial judge. It was never said, because these 38 bonds were capable of being traded and were in the public domain, it therefore followed that it was also in the public domain that you could set up a fund to do so. But I'm going to deal with that in a little bit more detail in the context of the public domain appeal. But it doesn't help you on construction. So the impracticality arguments are completely without substance, and that brings me to my fourth and final point, which is that there is certainly nothing in the wording of the NDA, or by way of factual matrix evidence, to support the appellant's bespoke construction. And can I ask you to go to paragraph 45 of my learned friend's skeleton argument, because this is where he sets out, under the heading, the correct construction, his arguments as to why his is indeed the correct construction. And one looks in vain for any words in the NDA on which the appellants rely in advancing this bespoke construction. Simply nothing. And indeed, their starting point is simply an assertion that the NDA is about exclusive control of the confidential information. And yet the skeleton doesn't identify which words in the NDA supposedly establish that foundational proposition. There aren't any. And on the contrary, it's clear from clause 1.1d that the NDA is not about exclusive control. Nor does paragraph 45 identify any factual matrix in support of the bespoke construction, nor does it identify any commercial rationale to explain why these contracting parties would have intended to adopt a patent law-inspired test, which is obviously a statutory test based on public policy considerations which have no relevance to the contracting parties here. And indeed, if the parties had wanted to adopt a patent law-inspired test, they would have used words which demonstrated that intention, but they didn't. Now, the final point to make is that it is worth noting that there will be many contracts which contain similar carve-outs to those in clause 1.1 of the NDA. For example, clause 5e in the Force India case that my Lord Justice Arnold is familiar with, it wasn't entirely identical, but it was relatively similar. And if the phrase public domain in the present case is construed as having this patent law-inspired bespoke meaning, it's not obvious why a bespoke meaning wouldn't apply to many other contracts, or many of those other contracts that contain similar carve-outs. And that will obviously create uncertainty for the parties to such agreements and those drafting them in the future. Now, I do accept that that's not in itself a reason for rejecting their construction and for adopting our construction, but it does highlight the potentially wide ramifications of their bespoke construction, and it highlights why they need compelling arguments to justify it. And paragraph 45 just falls woefully short. So for these reasons, the construction argument in ground 1 should be dismissed. Can I then come to ground 1, subparagraph 6, which is, was the confidential information in the appellant's possession or control? And can I start by sounding a note of caution, which applies both to ground 1, 6, and to ground 2. Now, an appellate court, although generally reluctant to review the factual findings of a trial judge, will of course do so if there's been a demonstrable failure to consider relevant evidence. We've given the quote from Lord Reed in Henderson and Foxworth in paragraph 43 of our skeleton. Now, in the case of grounds 1, 6 and 2, your lordships are being invited by the appellants to conclude that the judge demonstrably failed to consider 9 categories of relevant information. So that's 3 categories for ground 1, 6, and 6 categories for ground 2. Now, that is obviously a serious criticism of the judge's evaluation of the evidence and of his findings. However, the evidence that the appellants are relying on before your lordships comprises nothing more than selected snippets of the material that was before the trial judge. So you don't have the full witness statements of the witnesses or the full transcripts of the evidence of the witnesses or the full transcripts of oral opening and oral closing submissions or the complete set of written opening and written closing submissions, or indeed many of the documents about which evidence was adduced and submissions were made. Now, just to take one example, one of the points I made in oral closing submissions was that the evidence of Illiquidx's witnesses, including Mr. Cassim and Mr. Coleman, all strongly suggested that the setting up of a fund to trade Venezuelan sanctioned bonds was something that the financial services industry didn't understand, didn't do, and didn't appreciate could be done. Now, your lordships are in effect being invited to conclude that contrary to that evidence and the judge's conclusions in that regard, to which we'll come, it was in the public domain that a fund could be set up to trade undervalued Venezuelan debt. But it's just simply not realistic or indeed possible for your lordships to determine that the judge demonstrably failed to assess the evidence, such as that you should replace your findings for his without seeing the evidence. How could you possibly do it without seeing all of the evidence before the judge, including the witness evidence? And it follows that the appellant's approach to grounds 1, little 6 and 2 is fundamentally flawed.
Well, I understand the dangers of island hopping, as do my lords. It's a very familiar problem in this court, and so we're astute to the need to avoid it. But one of the themes of Mr. Moody Stewart's submissions, which I think you will need to deal with at one stage, is that it may be a question of level of generality. And in particular, the level of generality at which the business opportunity was interpreted in the judgment.
I will deal with that. What I'm going to do, I was actually going to deal with that when I come to ground 2.
Yeah, well, I can understand why.
In the context of public domain, and I was going to take you through various paragraphs in the judgment, making clear what the judge was finding in that regard. I mean, I should just say about the pleadings. I mean, there's my learned friend, I think, spent about 50 minutes this morning taking the court through the pleadings. Now, it is, and that was certainly one of the major focuses of my learned friend's approach in front of the judge, both in opening and in closing. Now, I should just say, it was an entirely fair criticism that Illiquidx's pleadings, in particular, the pleading of the re-amended confidential Annex 1 and the pleading of the business opportunity and the detail were not models of clarity, and returning to them hasn't been an entirely joyful experience today. But the position is that the pleaded case as to the business opportunity and the detail wasn't struck out. It was the basis on which the case was advanced at trial, and as the judge stated, and my learned friend accepted in front of the judge, the business opportunity, as found by the judge to be confidential information within the NDA, was part of the pleaded case. And there is no appeal against that finding. None. So the time for complaining about pleadings is well and truly over. I should just say, as regards the suggestion that I abandoned everything other than the high-level business opportunity and that I abandoned the investment strategy, there are 3 points to make. Firstly, I didn't abandon the investment strategy or indeed any parts of the pleaded case. And when my learned friend was today asked by Lord Justice Zacaroli to identify where I did so, he couldn't do it. On the contrary, he then took you to a passage provided by his junior, which showed that it made it absolutely clear that I didn't abandon anything. And on the contrary, the position was that we did maintain our pleaded case, although I completely accept that I focused primarily on what was described as the business opportunity. Now, I do have various other passages from the further supplementary bundle, which I can give you for your note if it would assist you in just making the point that I didn't resile. Would that be helpful or not?
Well, you take your own course, and I'm conscious that you said a couple of minutes ago that you were going to deal with this in the context of ground 2, so I don't want to take you out of it.
Well,
but I think we do need to be clear as to what the position is at some point.
Oh, well, in which case, why don't I take you to the paragraphs, to the passages at this stage?
All right.
So if, for example, we go to tab 6 in the further supplementary bundle, and at page 24, and line 25, that's right, sorry, on page 25, but secondarily, if I need to go beyond that, which I say I don't, but if I need to go beyond that, it was also the investment strategy for the purpose of monetising that, and we've identified all of the relevant parts in paragraph 72 of our opening. So here I was saying it's not just the high-level business opportunity, but if I need to go beyond it, we've also got the investment strategy. And then if you go to tab 7, page 28, lines 2 to 6, but also, my Lord, insofar as we have gone on to say, and we need to go on to say, I say we don't, but if we do, if we have to identify some secret source in addition to the core idea, we have the legal opinion and Ferrari and prescription and fiscal agency, all of which fall within those same definitions. So these were part of the investment strategy. And then if we go to tab 8, page 30, lines 11 to 20, so, my Lord, Illiquidx's primary case is that the confidential information provided to the defendant was this opportunity to set up a fund to buy sanctioned Venezuelan debt, including bonds, which were then undervalued. As I say, if I need to go further and show individual elements to that strategy, like getting a legal opinion that this is a sanctions-compliant fund, identifying Ferrari, identifying prescription and the fiscal agency structure, we've done all of that. It's all there in the pleadings. And then if we go to tab 9, page 32, lines 16 to 25, line 19. But even if you're right about that, we have extra elements. For example, the way to monetize is we have to go and get a legal opinion saying this is a sanctions-compliant fund, which is precisely what they did. And what's more, prescription is a key important part, particularly when you take into account the fiscal agency position. And then Mr. Justice Raja says, well, as I understand the point in relation to prescription and the fiscal agency point, it's a fantastic marketing tool because it provided a reason for investors to transfer their existing bonds over into the fund, exactly, and to do so for October 20. So if you got into the market before then, there was a time-limited opportunity. It is the collation of those 2 points which is what made that important, yes. And then the judge asked if it was sufficiently pleaded, and as we and he found in his judgment at page 135 that it was sufficiently pleaded. And then I think there may also be something in our reply, tab 11, lines 13, page 42, lines 13 and following. They understand full well the case they have to meet, being that the business opportunity is firstly the high-level business opportunity that we've been discussing for most part over the last 2 days, but also it's any combination or permutation of items in the detail, not necessarily the totality. We've clearly set out the combination of the business opportunity and how those built from detail in paragraph 72 of our opening skeleton, and that combination is valuable, as protectable, and wasn't in the public domain. So the suggestion that we somehow abandoned our case is, we say, utterly wrong. And that brings me to my second point, which is the judge made no finding that I abandoned the case. And on the contrary, it's clear from his judgment that it wasn't abandoned. And we'll see that when we come to, in particular, the schedule to his judgment. And the third point is that I rely on this appeal, on the judge's findings in respect to the business opportunity. So I'm not in any way trying to go behind the judgment and elaborate on it. And what I do say, however, is that the judge didn't confine the business opportunity in the way suggested by my learned friend, but I'll address that when I come to the judgment itself in due course. So those are the general points I wanted to make at the start. Can we now come to the grounds of appeal? And page 16, paragraph 1.6 of, core bundle tab 1, page 16. So this is where they're dealing with the paragraph 1.1c and d carve-outs, the three items of evidence. The judge further erred by failing to take into account or give proper consideration to paragraphs 1.1c and d, which exclude from protection under the NDA information that was already in the possession or control of Altana or Brevent. And so we then see that three categories of information to which the judge supposedly failed to have regard are then identified. And the punchline is then in little 7. Had the judge taken proper regard of the matters at 6a to c above, he would have held that no aspect of the business opportunity as relied on in closing remained protectable as confidential information under the NDA by the date of the alleged misuse. Now, just taking the three items in turn, just looking at item little 6a, so this is the email bulletin from Stiefel with the attached price list and attestation form. And so that was the document you were shown at supplemental bundle tab 7. Now, it is dated, as you see, from the last line, 21st of August 2019. So although there is no reference to clause 1.1d in the grounds of appeal here, in the context of little a, it is clear that this argument is the argument is that this document was in Altana's possession or control and so fell within the scope of 1.1d. So this is a 1.1d argument. Then item 6b is the unchallenged evidence from Mr. Robinson and Mr. Kastner about their familiarity and use with the use and purposes of multi-cell structures. And so the argument here, they do identify the relevant provision. The argument here is paragraph 1.1c. And then if you look at item 6c, this is the unchallenged evidence of Mr. Kastner about a Pictet-managed Luxembourg investment having bought some Venezuelan bonds in September, and Mr. Kastner's WhatsApp message. And as with item 6a, there's no reference in this subparagraph to 1.1d, but the argument must be that the material fell within 1.1d. So the issue is, was there a demonstrable failure by the judge to consider whether these three categories of information fell within the scope of 1.1c and d? And the answer is an unequivocal no. And a fundamental problem for the appellants is that at trial they didn't seek a finding from the judge that these items fell within the scope of 1.1c and d. And it follows that they cannot now criticise the judge for failing to make findings which they didn't invite him to make. And it is a notable feature of both the grounds of appeal and the appellant skeleton that those documents don't even assert that the appellants invited the judge to find that these three items of information fell within 1.1c and d. I mean, if, for example, you look at paragraph 47 of my learned friend's skeleton, at trial a number of documents were brought to the judge's attention, which demonstrate that key components of the business opportunity were in fact in possession or control of one or both the appellants, therefore ought to have been subject to the carve-out. The judgment doesn't deal with any of these. The appellants say the judge wrongly overlooked these points, perhaps as a result of the shifting nature of IX's case. So they don't actually assert they invited the judge to find these items of information fell within 1.1c and d. But let's just take them in turn and see what in fact happened. So can we start with the Stiefel email? That's item 6a. And so that's supplemental. I mean, we don't need to go to the email itself. You've seen it relatively recently in supplemental bundle 7, supplemental bundle tab 17. But can you just go to the appellant's skeleton argument, paragraph 48.1, where my learned friend deals with it? Now, this paragraph does not assert that the judge was invited to find that the email of August 2019 and the attestation form fell within 1.1d. And he wasn't. And my learned friend didn't identify today, in oral submissions, where the judge was invited to deal with it. We've made this point in our skeleton. He hasn't responded to it. Could you just go to our skeleton, paragraph 44. And there we say in the first sentence, the appellants assert the judge purportedly overlooked these matters as a result of the shifting nature of IX's case, but none of the documents or evidence on which the appellants now rely was cited in the defendant's written closing submissions as even potentially relevant to clause 1.1c to d. And if you then look at footnote 12, there were only 2 references to clause 1.1c in the defendant's written closing and no references to 1.1d. Now, if we just go to my learned friend's written closing submissions, can I ask the court to take the supplementary bundle and go to tab 47, page 334. And if we look, paragraph 103 on page 334, my learned friend said, aside from the OFAC website itself, information about the site and its contents and the sanctions and general licenses was also put into the public domain via email updates.
Sorry, I haven't found where you are.
Paragraph 103, page 334.
Oh, sorry, it's I misheard. Thank you.
So aside from the OFAC website itself, information about the site and its contents and the sanctions and general license was also put into the public domain via email updates from brokers such as Stiefel, including a price list, etc., and the attached attestation form. Galena accepted that anyone wishing to trade such bonds via Stiefel would have to complete the attestation form, which identifies the general licenses. She finally accepted that such information was circulating in the market, but somehow lacked further explanation. So the Stiefel email was relied on as a public domain document, i.e. clauses 1.1a and b. So that's my learned friend's written closing. What about his oral closings? If we can just go to tab 44, please, in the same bundle, and page 245. And in line 5, you can see that my learned friend is dealing with clause 1.1c. And in line 13, we're just going down there, he says, what about the Stiefel stuff? And so it's clear, because he's dealing with 1.1c, that he's not referring to the August 2019 Stiefel email, but he's referring to earlier Stiefel emails, ones which predated the supply of the confidential information. Now, if you also go to page 246, lines 15 to 24, he says, we do indeed say that we rely on these materials as indicative of things being in the public domain anyway, but insofar as it said that Mr. Robinson had to have read every single one of the Stiefel updates or anything that was sent to him, That's not what the clause says. It just says it's in the possession or control. So it's for me to identify what those are. My learned friend is right when he says the burden is on me to show something's in the public domain. So my learned friend was accepting that it's for him to clearly show which particular document he relies on for which particular carve-out. Now, as to these earlier pleaded Stiefel, could you also just go to paragraph 249 and lines 17 and following? He says, so we've exhibited to the pleading Stiefel emails where Mr. Robinson is offered the opportunity to buy bonds and the attachments that say these are the forms you have to fill in order to deal with them, and Bloomberg updates and the Torino report, all of which would be in Altana's power and control, whether or not Mr. Robinson had read them. And so you see that what he's referring to there are the pleaded Stiefel emails. Now, so these are earlier ones, i.e. ones before the August one that he's relying on in this grounds of appeal. And can I just make that good, take you to the core bundle, tab 18, page 259. So this is my learned friend's re-amended defence. And 259, paragraph 13. In all the circumstances, the first and second defendants have, since well prior to any relevant contact with the claimant, been well aware of the distressed debt sector, and the first defendant has been subscribing to information about the investment potential of Venezuela and PDVSA for many years from professional research providers such as Stiefel. The first defendant has approximately 30 employees, part of whose work is to collate such information and research in distressed debt opportunities from public sources and multiple external brokers and research houses, including leading organisations in emerging markets. Paragraph 14. By way of example, an amended defence Annex 1 here too is a non-confidential email update received by the second defendant on 3rd of September 2017 from Stiefel. So that was nearly 2 years before the NDA. And if we then go over the page, say quotes from it, further and without limitation, by way of illustration of information both published to the world and received by the defence independently of the claimant, at Annex Defence Amended Defence Annex 1 are the following third-party publications from the defendant's disclosure, which will publish at or around the date of the document in each case and read by one or more of the defendants at or around that date, save as indicated otherwise. And then you've got a Stiefel in 14.1, a Stiefel email of the 10th of January 2018, so again before the NDA, before the relationship began, and at 14.2 a Stiefel newsletter dated the 6th of February 2018, so again before the relationship began. And there is no reference to the August 2019 Stiefel email. That simply wasn't referred to in the re-amended defence. And so the upshot is that my learned friend never invited the judge to find that the August 2019 Stiefel email fell within clause 1.1d. So grounds of appeal item 6 little a is just fundamentally misconceived. And I should just say it's notable that there is no appeal on the basis that the email showed that the business opportunity was in the public domain. That hasn't been appealed. Now, so that's the first one. Then we come to item 6b, and that's Lee Robinson and Mr. Kastner's knowledge of multi-cell structures. And can I just ask you to go to my learned friend's skeleton, paragraph 48.2. And my learned friend repeated the point today that it's a point of detail, but we see here it's apparently significant because it relates to the judge's finding that the appellants exploited the idea of a multi-cell structure as part of the business opportunity, and reference is made to item R of the schedule. Now, can we just remind ourselves of item R to the schedule? If we go to the core bundle, tab 7, page 132. And so this is where under R, item of detail is our claim management presentation, part of the fund detail, and we see under description, slide 7, fund structure for contribution in kind, and so on, and then Is it confidential information? Yes, conceded by the defendant, so they accepted this was confidential information. Is disclosure permitted? No, although the information in it related to the proposed fund structure had been trailed in the AICF presentation, that was still information which was relatively secret. And then misuse, yes, the use of a multi-cell structure was part of the business opportunity which the defendants have exploited. And as I made the point before, there is no appeal to the judge's finding in relation to item R. So it is mystifying as to why this ground of appeal is brought, because even if the appellants were to succeed on item 6b, it wouldn't result in a successful appeal. The judge's order wouldn't be set aside, particularly in circumstances where they don't challenge item R. Now,
sorry, don't understand that.
Yeah.
Is this not a challenge to that item?
Is this a challenge to item R?
Yes.
Well, one looks in vain in the grounds of appeal for any reference to item R. I mean, I suppose the best one might be able to say is it's an implicit appeal in relation to this, but it's pretty surprising that the grounds of appeal doesn't actually explicitly say we are seeking to appeal the factual finding in item R, but it doesn't.
Well, I take that point, but just to put this into slightly different context, you referred to the, and rightly referred to the judge's order. What does the judge's order actually say about these different items? Can we have a look at that?
Of course. Sorry?
Yeah, well, that's unsurprising. So what we see is at page 90, judgment claims of liability, breach of confidence, and infringement of trade secrets, which tells you nothing about the extent of the findings. Now, that's not a criticism, it's understandable, but what that tells you is that we have to look at the judgment to see what the extent of the findings are.
Yes. Absolutely. I mean, my lord, I'm not going to take this point too far, but it is a little surprising that neither in the grounds of appeal nor in paragraph 48.2, where my learned friend is dealing with this, does he say, oh, well...
I mean, rather belatedly, he's put it
Yes.
in his schedule, which I've just looked at.
Yes.
But anyway, you've made your point.
Anyway,
I've
made that point.
It's not very clearly...
I'm not going to take that point any further. But I think what is important is there is this really crucial point of context, which is there wasn't an issue before the judge as to whether or not the appellants knew about the general use of multi-cell structures for hedge funds, hence the evidence being unchallenged. Of course they know about multi-cell structures, or it simply wasn't an issue. But the relevance of the multi-cell structure in the context of the business opportunity that was being introduced by Illiquidx was set out in paragraph 54 of the judgment. Now, can you just go to that? And in paragraph 54, the judge says, he refers to the claim management presentation, part R of the detail, which explained the proposed multi-cell structure of the AICF, which would allow existing holders of Venezuelan debt to invest in kind in the AICF by exchanging their debt for shares in the relevant cell of the AICF. This presentation explained the protection conferred by multi-cell structures and the advantages of the AICF being able to bring litigation on behalf of all investors. And so a potential investor who owned Venezuelan debt could exchange their debt for shares in the relevant cell of the fund to be set up. And that was the real attraction for potential investors. That's the fund structure for contributions in kind. And so Mr. Kastner's general knowledge of the use of multi-cell structures was utterly irrelevant. What was valuable was that Illiquidx told them how those structures could be used in the context of this particular opportunity. And there's absolutely no assertion in paragraph 48.2 or the grounds of appeal that they possess that information.
What made it particularly useful here rather than it just being a fairly standard way of running a fund?
Well, because what you could have is you could have investors who had bought their Venezuelan bonds and were currently looking at 15 or 20 cents on the dollar. And what they could then do was they could buy into the fund, exchange their debt for shares in a cell in the fund, and then what would happen is the fund would manage their investments and indeed would manage on their behalf prescription and limitation, which otherwise, because of the fiscal agency situation, they would have to manage on their own. So this is why the multi-cell structure worked together with fiscal agency and limitation and was effectively what was described as the jewel by Mr. Robinson. This was a massive marketing tool for investors. So simply saying they knew about multi-cell structures completely misses the point. And I'm going to come to the various sections in the judgment where this all becomes apparent in due course.
What's the magic of the multi-cell structure here as opposed to just a company where you buy shares in exchange?
As opposed to having a single structure?
Yes.
I have to say I'm not sure I can remember that. And I'm not sure the judge's judgment actually deals with that. But it was regarded by everybody as the jewel.
Right.
As one of the big marketing opportunities for the parties. I mean, that's why one of the difficulties with this island hopping is quite problematic, because we only have little snippets of the evidence that was in front of the judge, and we don't have all of the witness statements, all of the transcripts.
But you can always put investments into a company in return for shares.
Yes. Well, if the fund allows it. But not every fund allows you to do that. But one of the things they were doing here, it was they were going out to investors and they were saying, if you're holding these bonds at big losses, we think it's going to be a fantastic opportunity. Exchange it. We can take your contributions in kind, and we will then manage your debt, which otherwise you would have to be filing your limitation claims. We're going to be doing that all for you. And so that was the point of context that I wanted to make about multi-cell structures. Can we just go to paragraph 48.2 of their skeleton? And what is notable is that 48.2 doesn't assert the judge was invited to find that this item of knowledge fell within clause 1.1c, and he wasn't. Now, 48.2 refers to their written closing submissions. And paragraph 93. Now, can we just see what, in fact, those closing submissions said? And can we go to tab 47, page 331? Now, so this is dealing with the Kanema Capital presentation. So this was the the first of the documents they rely on as being in the public domain, in their public domain arguments, which I'll come to later. And this is what my learned friend said in written closing. It's accepted that the Kanema Capital presentation constitutes confidential information for the purpose of the NDA. However, by reason of the circulation of the various versions of the presentation without obligation of confidentiality by IX, and at least Mr. Illardo prior to the JV, the entirety of its contents were placed in the public domain for the purposes of clause 1.1 of the NDA. Apart from this, individual elements of the presentation were already known generally and to the defendants, but the central point relied upon by the defendants is publication on numerous occasions by IX and Mr. Illardo, apparently among others. The defendant's case is that the publication of this document in February and March 19, without obligation of confidence, put the central idea of the business opportunity in the public domain. And then paragraph 93, Lee Robinson was not challenged on his position about the public nature of the contents of the presentation. Stefan Kastner was clear that multi-cell is very common, and in any case, he already knew it from his familiarity, nothing novel, very uncommon. So when you read paragraphs 93 and 91, it's clear that they were advancing a public domain argument, and there was no express assertion that the knowledge of Stefan Kastner fell within 1.1c. And there's no reference whatsoever to Mr. Robinson and his evidence. And if you then go back to their skeleton, they also refer to paragraph 48.2 to their oral closings. And if we can just have a look at that and the reference they give, supplementary bundle tab 44, and going to page 250, please, lines 20 and following. Mr. Moody Stewart, if I'm wrong on that, which, my lord, one has to be realistic is a possibility, if I lose on that construction, then these are the fallbacks. In particular, within this, when it comes to having a Cayman fund or a multi-cell structure, we rely, as you see at paragraph 93, even if that were within confidential information, it is in the public domain. And we rely on the matters of evidence that were given to that end by Mr. Robinson and Mr. Kastner. So it was a public domain argument. And there's no reference there to 1.1c. So the criticism of the judge, that the judge had no proper basis to disregard Mr. Kastner's evidence, is just unjustified. So then going back to paragraph 48.2, this also criticises the judge, in the last line on page 18, for not having regard to the telephone transcript excerpts where Mr. Amore acknowledged that Mr. Robinson was already familiar with such structures. My learned friend didn't develop this today, but he doesn't suggest in his skeleton that the judge was invited to make any such finding based on this transcript, and he wasn't. And so again, the upshot is that 48.2 doesn't come close to establishing any demonstrable failure by the judge in relation to item 1.6b of the grounds of appeal. And that brings me on to the third item. My lords, do I have about 3 or 4 minutes?
Certainly.
So this is the purchase of bonds by Pictet. And if you could just look at the appellant's skeleton at paragraph 48.3, yet again, it doesn't assert that the judge was invited to find that this item of information or the WhatsApp message fell within clause 1.1d, and he wasn't. And as I've said, there were no references to clause 1.1d in the appellant's written closing submissions. Indeed, there was no suggestion before the judge that the purchase of bonds by Pictet in September 19 communicated the business opportunity to Mr. Kastner or the appellants. And unsurprisingly, paragraph 48 doesn't assert that the judge was invited to make any such finding. Nor was it suggested at trial that this September 2019 purchase somehow rendered Pictet's 2019 email incorrect, which is a suggestion they make in the grounds of appeal at item 6c, but isn't repeated in paragraph 48.3 of my learned friend's skeleton. So again, the upshot is that paragraph 48 doesn't come close to establishing any demonstrable...
Sorry, I didn't quite follow that point. I think you might have said the September email, is that right? Or
Sorry, the September purchase.
September purchase?
Yes.
And the question is whether that renders the July email.
Incorrect.
Is that right?
Yes. If you just go to their grounds of appeal again, so tab 1, page I think 15 of the core bundle. Well, this is over on page 16 and little c. Yes, had the judge not ignored that evidence, he ought to have held that the information in the July email from Pictet indicating that it was not allowed to trade those bonds because of sanctions was incorrect. Now, that's not a point that they've repeated in their skeleton, but it was the point that I was making. It was never suggested at trial that the September purchase somehow rendered the July email incorrect. And so we say that paragraph 48.2 doesn't come close to establishing a demonstrable failure by the judge. And so there was no demonstrable failure in relation to any of these three items. And what my learned friend is trying to do is to advance a new case that wasn't made at trial. And I should also make the point that none of these three items communicated the business opportunity as found by the judge, which I will address in some detail in the context of ground 2 tomorrow, I assume.
Yes, I think that would be wise. Very good. We will pause there and resume at 10:30 tomorrow.